continue our discussion on civil liberties and civil rights. No other freedom but religion has resulted in more cases before the federal courts and the Supreme Court, more so than speech and press and assembly combined. The Free Exercise Clause basically says that American citizens can practice the religion of their choice without state interference. What that means is that there can be no special government burdens on religion. For example, we do not allow the governments to tax religions, nor can there be a religious exemption from laws binding to all. For example, you cannot have a religion that states, even though it's been tried, you cannot have a religion that states that it's part of their religion to use drugs, smoke marijuana, and so forth. Not going to be allowed. Problems? Well, what do you do with conscientious objectors that refuse to fight in the military because of their religion? What about those that, like Jehovah's Witnesses, that refuse to work on Saturdays, their particular holy day of the week? What about refusals to send children to high school? And you can even, cases have been heard on whether or not you can refuse to allow your children to be vaccinated before they're sent off to kindergarten. All these cases you'll find discussed in your textbook, and you may want to think about before you look at them. The Establishment Clause sets up a wall of separation between church and state. And finally, by 1947, you have a case in Everson versus Board of Education where the court came up with some guidelines that if the government is going to get involved in a religion, it has to be a secular purpose. For example, can a state government provide textbooks for all children, including those in public schools and in private schools? And the court said yes. Does it neither advance nor inhibit a religion? And no excessive government entanglement with religion. But that particular word excessive has been the cause of many lawsuits and eventually get to the United States Supreme Court on what is exactly excessive. Continues to be a problem. But you look at, as a result of the Everson case, school prayer, creationism, as opposed to the theory of evolution being taught in schools, in school release time, particularly in states like Wyoming and Utah, where you have a number of LDS seminaries. What the courts have said is that as long as the classes are not on school property, that release time for seminary classes and catechism classes, like for Catholics, has to be allowed. What about nativity scenes on public parks during Christmas time? All of these cases, continue to be part of the news when it comes to the Establishment Clause. Some kinds of aid to parochial schools are allowed as long as you are directly helping the children and not protecting or helping the religion. Going on to the 4th, 5th, and 6th Amendments. In Mapp versus Ohio, the court came down with what's called the exclusionary rule, which basically says that no evidence obtained as a result of an illegal search or illegal actions by the police can be used in a court of law. And those, that look at the Mapp case, the question is, are police being punished for illegally obtaining evidence? And the court has upheld that. Yes, the police are not going to be allowed to use tainted evidence in a court of law. Search and seizure under the 4th Amendment, that in most cases the government has to have a search warrant, but sometimes they don't have to. If it's incident to the arrest, when the police are arresting somebody, they can search their person, their pockets, and so forth, and anything they find which is illegal can be used in a court of law. Things in plain view are under direct control of the detainee. For example, those things in your vehicle. If it's stopped on the highway and something Illegal is on the back seat, it's in plain view. Immovable scene of crime, like a car or a boat, or for that matter, a skateboard, I guess. If the police would be concerned that if by the time they got back you were gone, it's a movable scene of crime. If you give permission to have search. Breathalyzer in your analysis is not considered a violation of the Fourth Amendment. You must, if you want to keep your driver's license, you have to submit to a breathalyzer if the police suspect that you are driving while impaired. Confessions and self-incrimination. Until 1964, the police could ask you any questions and they could use it in a court of law. But in Escobedo, they decided that if you're, as the arrestee, you have to be informed when the police are questioning you down at the police station. You have to be informed of your right to remain silent under the Fifth Amendment. That was extended in 1968 in the Miranda case, that even before they took you down to the police station, they had to tell you that you had the right to remain silent as they're putting the cuffs on you. Question regarding the Fifth and Sixth Amendment nowadays is, are we protecting the criminals enough with Escobedo and Miranda that when they're at trial in front of a judge, should defendants have to take the witness stand? Modern times, look at, since 9/11, looking at the Patriot Act, that some liberties have been severely restricted in regards to crime and due process, that in order to fight terrorism, sometimes we're going to have to give the police a little bit more power. Examples of military tribunals used to try non-citizens that are suspected of terrorism have been upheld by the court. Race and strict scrutiny. In Plessy versus Ferguson, 1896, as an example, the court decided that separate but equal facilities based upon race was lawful. But in 1954, in the case Brown versus Topeka, the court overturned the Plessy decision and said that school segregation and all types of discrimination based on race were suspect classification. The Civil Rights Act in 1964 further outlawed private discrimination, and as a result we've had situations of equal opportunity versus equality of result, and brought about by the 1970s affirmative action to make sure that minorities were given preference for hiring and to get into universities and colleges. That changing attitudes towards white integration, by whites towards school integration. You can see from the graph that as time has gone on, integration of schools has, gone the way that, this is the right thing to do. Gender classification, suspect, for example, different drinking ages for men and women, the Junior Chambers of Commerce and their exclusions of women from their meetings, mandatory pregnancy leaves for women in the workplace. Those have been suspect, and as a result, for example, you've had to have that men and women can have pregnancy leaves. Not suspect have been all boy and all girl schools. There's reasons to have an all boy and all girl school. Statutory rape laws do target male offenders. Military draft, so far, and we haven't had the draft since the Vietnam War in the 1970s, but right now it's only men that have to register for the draft. If the draft ever comes back in, they'll probably get rid of this. Abortion as a right of privacy. Roe versus Wade decided that there was a Ninth Amendment right by women that to protect their own bodies, it was a privacy point. The Casey decision 10 years later said we can put restrictions on abortion, a 24-hour waiting period, parental permission for minor women, info on alternatives to abortion has to be given to those women who are seeking an abortion.